A tenant actually reached out to us last week on this matter. One day, the tenant got a call from a strange number, and it was the landlord. So the landlord told the tenants intimidatingly, "You have to move out of my property." You know that a landlord cannot throw out a tenant from his property by virtue of the fact that the said tenants paid monies to the caretaker, obviously on behalf of the landlord. This is a classic situation that happens every now and then in Lagos.
House rent has increased to 24,000 naira from 5,000.
Dear God.
And we have a classic example before us. A tenant actually reached out to us last week on this matter. The tenant approached the caretaker and agreed with the caretaker based on the inclusive charges and the rent itself to pay a total sum of 1,050,000 naira. Good enough. The caretaker told the tenant or the prospective tenant, "Oh, let's go see the landlord." And on getting to see the landlord, obviously the landlord is not in Nigeria, so Lagos landlords are always abroad. So put the call across, and they all agreed that the tenant can pay the rent. However, in staggered sums as the tenant's peculiar condition. Well, good enough, after the tenant had satisfactorily paid all the rents, and in her own mind she felt victorious and she could move in. Mind you, earlier the caretaker had informed the tenant that he is going to take care of all repairs and structural damage to the property. On the strength of that, the tenant felt in her own mind she had arrived. After a period of time, the tenant reached out to the caretaker to no avail. One day, the tenant got a call from a strange number, and it was the landlord. So the landlord told the tenants intimidatingly, "You have to move out of my property. The supposed person you paid money to, I don't know him from anywhere. And moreover, assuming but not conceding, I know this person. This person did not remit 1 naira to me." And so the landlord threatened her and told her, "You have to pay 100,000 naira extra demand." Now, the tenant is confused and currently in a maze. Mind you, the tenant is still grappling with the possibilities of her even fixing her property since she has not even seen the caretaker. This was the classic case of one of our listeners.
You? Jesus. It is shock me.
What is the position of the law on this? The law is very clear. Under the law of agency, it simply states, as beautifully expressed in the Latin maxim, qui facit per alium, facit per se. Anyone who acts on another does the act itself. The caretaker collected monies from the tenant and claimed he acted on behalf of the landlord. Furthermore, the caretaker took a step further by convincing the tenant to do a conference call with the landlord, depicting or showing that there was an ostensible or apparent authority decoded on the caretaker acting on behalf of the landlord. This itself clearly represents a clear space of the law of agency. The caretaker strictly acted on behalf of the landlord, and case closed. Now, to make things even very clear, Section 47 of the Tenancy Law of Lagos State 2011 makes it very bare. It defines who a landlord is as an attorney, solicitor, agent, caretaker, emphasis on caretaker, that receives, stands on behalf, monies on behalf of the landlord, as the landlord. In this case, the caretaker took monies on behalf of the landlord and regularly stands and represents the landlord in that capacity. The tenant in question should have nothing to fear. As a matter of fact, this is what the tenant should do. And I know a lot of us are in this situation. Number one, the tenant should reject the offer made by the landlord to pay the 100,000 naira, as it has no legal basis at all. Number two, The tenant should gather all electronic evidences, payment receipts for the said property, and any form of documentary evidence, because the tenant itself is backed by section 84 of the Evidence Act 2011 that makes electronically generated evidence admissible in any competent court of law. Should the landlord decide to go to court in his own wisdom and understanding, this believing and thinking he has the point to prove, then the said tenant can obviously get out those electronically generated evidences and tender it in court, and it will be rightly admissible. Lastly, the tenant should be at ease with herself. Like any other negotiant who may be going through this, the law remains your foothold. Thank you.